Her Honor, presiding over the Rust trial in New Mexico, where Alec Baldwin is the defendant charged with involuntary manslaughter, said that she would like for any objections stated by either side that they have to approach the bench. No objecting from the defense table, no objections from the state's table. That if either side have an objection, they have to get up, walk up to the bench, and they have to put their objection on record from there. The judge said that it's been very contentious between both sides, and that's what she did in the previous trial of Hannah Gutierrez. Well, Alec Baldwin's attorneys just won't stop. Your Honor, he says, I've never seen this before. What? I have. To put it mildly, okay? The state and the defense, they don't like each other, and they are throwing shots at each other. And I've seen it before in trials where judges have told both sides that anything that they want to put on the record when the jury is in the room, they have to do it at the bench. And Baldwin's attorney just won't stop. Listen to the audio at the end. And shout out to Her Honor. She let him know that the court controls the courtroom and that she is not going to change her mind. Him saying that he's not ever seen this before, yes, he's correct. It is more time consuming. But apparently, y'all don't know how to behave because, see, even just saying objection, relevance, you can say it in a tone that makes the jury think the other side is stupid. What if you say, objection, Your Honor, relevance? See what I mean? You see how that switched up? Tone matters, and the judge knows that tone matters, and the court is doing what it is supposed to do by protecting the jury. And by protecting the jury, in theory, the court is protecting the defendant, Alec Baldwin, and the court is protecting the trial process. So listen to this clip of Baldwin's attorney just not letting it go. And Check L said what? I'm going to discuss this pretrial hearing in a live later on today.
Yes. So I'm glad I saved my rebuttal because I do want to address this issue, Your Honor. What I would ask and urge the court, because I think that this system could disrupt the ability to cross-examine and disrupt the defense. It is not, as I think the court will acknowledge, it is true the court has great discretion. I think that deciding that before the trial even begins is an extreme use of discretion, just genuinely. I know that issue happened at the prior trial. I'm asking and urging the court to give an opportunity, at least to the defense, to just simply say, and I think my suggestion works, right? It's just objection, relevance. There's no other words coming out of my mouth ever during objections at a trial in front of the jury, and to allow us to have an opportunity to have what I would call a normal procedure. Because if every time there's any progress going on with a witness, they're standing up and they're making everybody come to the bench, they're disrupting the ability to cross-examine. They're disrupting the ability to put on our case. So what I would urge the court and ask the court to please do is to allow us at least, if after the first witness even, the court wants to revert to what they did later on in the Hannah Gutierrez retrial. But I can tell the court I've tried many, many cases. I've never had that issue before. I've never had that issue with one witness in one case. So I'm asking the court to at least give the parties a chance to do it. I also am very concerned about the time, schedule, and everything else. There are lots of objections that are just objection relevance. The court will rule. If the court needs to hear more, we come up. And I'm urging, almost begging the court to at least let us start that way, and then the court can, like this, and not hear from me further on this issue.
Yeah, after all that, the judge said that's going to be a big fat no.